Thank you, Dr. Batra, and thank you, ma'am. It was one session which I thoroughly enjoyed, and you're doing human service, and we really appreciate that. And from one stalwart to another, let me invite on screen Justice Iqbal Ahmed Ansari. His topic for the day is Cognisance and its different perspectives. Let's give him a big round of applause.
Welcome, Justice Ansari. You'll have to unmute yourself. That's my request. We can't hear you. You have to unmute yourself. Unmute. Unmute is the second most popular word of 2020. First is COVID.
I know, but
we can hear you now. We can hear you. We can hear you,
Can you
sir.
hear?
Yes,
Can
sir.
you hear?
Yes, absolutely. Just for our viewers, Justice Iqbal Ahmed Ansari really doesn't need an introduction in this country, but he was the acting Chief Justice of the... am I making a mistake again? You were the Chief Justice of the Patna High Court. Yeah, I corrected myself before I get your beat. And he's now a part of the... he's the chairman of the Punjab Human Rights Commission, and a lot of people, youngsters look up to. So all yours, Justice Ansari. We look forward to your conversation.
Unfortunately, I have selected a topic which may be of interest to students of law, but may not be to people who are not involved in law.
So there is legal professionals who have joined us. So they love it.
I'll try to make it enjoyable even for those who are not in the business of law. I am on a very preliminary and fundamental question of law, which is known in the court parlance as cognizance. Cognizance has no fixed meaning or there are two kinds of cognizance recognized under the CRPC, and one more thing which we will come to is that how many times cognizance of a case can be taken. Is it only once? Because there is a decision of the Constitution Bench of the Supreme Court which says that there is only once that the court takes cognizance. I must tell, particularly my youngsters, that a decision of a court, even if it be of the Supreme Court, may be binding on the judicial side, but so far as the academics is concerned, it is open to analysis and, if necessary, criticism. Now, as far as cognizance is concerned, broadly speaking, there are two ways of cognizance. When a complaint is presented by a complainant to a magistrate, he cannot proceed to deal with the complaint without taking cognizance, provided he wants to deal with the complaint as a complaint case. So what he does, he goes through the complaint, he finds out what offense or offenses are being disclosed by the complaint, and if he decides to examine the complainant and record his statement or her statement and the statement of his or her witnesses, the cognizance is over. But merely applying one's mind to the complaint and taking a decision as to what should be done is not a complaint. Whereas there is a judgment of the Supreme Court about 6-7 years ago which says in a particular case that when the court applies its mind, cognizance is taken, and therefore it cannot be sent to the police for investigation. Now let us understand how the cases under the investigation is taken cognizance of. When a first information report or FIR is lodged with the police investigates the case. After the investigation is over and the police find there is a case made out or not made out, whatever be the result, it comes in the form which is called police report. This police report can be a charge sheet, it can be a final report. Charge sheet means that the police has found materials against the accused or accused persons. And if it is a final report, it means that the police has found no material or no such material on the basis of which the case can be proceeded with. And then it is presented before the court. If there is a charge sheet, normally court takes cognizance, it applies its mind and decides to proceed. Proceed means issue summon or warrant. This is called cognizance. But if the police on investigation has given a police report saying that no case appears to have been made out, the court is not debarred from applying its mind, and if it finds that there is a case against the accused or accused persons, then also court can take cognizance and decide to proceed against the accused by issuing summons or warrant as the case may be. So this is one way of doing it. The second one is, as I said, with regard to complaint. When the court decides, when a private complainant files a complaint, courts go through the complaint and decides to proceed with a complaint case. If it decides to proceed with a complaint case, then it records the statement of the complainant and the witnesses, if any, present. So this is how these two are two different stages. In the case of the police investigation, the cognizance is taken after everything is over. Whereas in the case of a complaint, the very first time it comes before the court takes cognizance. Because you may be knowing, many of you, that an FIR is also has to be sent to the police at the earliest, to the magistrate. Now, magistrate goes through the FIR. Obviously, he comes to know whether there is a case or there is no case. This does not mean cognizance has been taken. So, while in the police report or in the cases where investigation has been done by police, cognizance is taken only when the police report is given. In the complaint case, the cognizance is taken at the very first stage if the court decides to proceed with it as a complaint. Why I say if the court decides to proceed with the complaint is that the court may decide not to proceed with the complaint as a complaint case and send it to police for investigation. Supposing I file a complaint before the magistrate goes through the complaint and finds there is a case for the police to investigate. Say, for instance, a case of murder has been, complaint has been made, a case of maybe rape has been made where medical examination and so many things are required to be done. Then in that event, he may send it to police. So the question arises as to how magistrate can send it to police when there is a complaint case, because he is applying his mind. This is called pre-cognizance stage. That means before taking cognizance, my reading of a complaint, applying my mind to find out as to what offense is disclosed and to determine as to whether I should send the complaint to the police for investigation or I should deal with it as a complaint case, is not taking of cognizance. Cognizance will be in such a case only when I decide to proceed with the complaint as a complaint case. This is what Sushant Singh's case is, that the FIR has been registered. So far, we can't say cognizance has been taken because the police investigation is still pending. Once the police investigation is over, the police submits a report, and on the basis of the report, if the magistrate decides to proceed further and issues process for trial of the accused, or then in that event cognizance is taken. Now, the complication arises in some cases where cognizance is barred under the law. Say, for instance, even in the CRPC, there are some offences for which sanction is necessary before the court takes cognizance. So, in a case of promulgation of Section 144 order. Say, for instance, curfew and all, are orders under 144. In 144, there is a prohibitory order. Don't assemble don't assemble more than 5 persons, etc., etc. Now, if such an order is violated, then how the matter comes to court? CRPC says that no cognizance can be taken in such a case of violation of any order passed by an executive officer if sanction has not, if there is no complaint, and the complaint has to be made by the officer whose order has been violated. That means if I am the district magistrate, I have promulgated an order under 144. If my order has been violated by anyone, then I have to make a complaint. Subsequently, because it may not be necessary that I will remain at the time when the complaint comes for saying that order has been violated. In that event, the Supreme Court's decision is that either the successor in office, that means whoever might have succeeded me as the district magistrate, or any officer superior to me can make a complaint. There is a bar. Now, in this particular case, the problem arises that violation of Section 144, which is punishable by Section 188 of the Indian Penal Code, which many of the students will be knowing, is or has been made cognizable. Cognizable means police can arrest without warrant. Now, how the police can arrest without warrant? Obviously, police can register a case. There can be an FIR. Police registers the case and arrests the man. This is cognizable. But unfortunately, corresponding change or amendment in 188 has not been made. With the result, while 188 says that no court can take cognizance except on a complaint made by the officer whose order has been violated, CRPC makes in the offense under 188 as cognizable. This is a flaw of the legislature. I don't know for what good reason the legislature has not yet corrected, because the moment they had made Section 188 cognizable, they ought to have made offense where the cognizance can be taken on the basis of the police report. Whereas under the present CRPC, it cannot be taken, as I said, except on the complaint of the officer himself or his successor in office or his superior. Now, there are cases where sanction is required. Say, for instance, in a case where a public servant commits an offense, but if the offense is committed in discharge of duties or in purported exercise of duty, then in that event, Section 197 says no cognizance shall be taken. No cognizance shall be taken means there is a bar. Now, I make a complaint of, say, Prevention of Corruption Act, or I make a complaint of such a nature where one can say that it has been done in exercise of my duty. Say for instance, in a case where the district magistrate is present, the crowd has become violent, and he asked for lathi charge, which could have controlled, but instead of lathi charge, he asked for firing. When the fire opens, somebody gets killed. Now, in that event, it can be said that he has exceeded the power, but nonetheless, his exercise of power is protected by 197. We must bear in mind that when the protection under Section 197 is sought by an officer, it means there is an offense, but the offense has been committed either in discharge of the public servant's duty or purported discharge of the duty. That means under the color of the office. For instance, I am entrusted with the property of the government, right? Say, for instance, I have the crops with me available. I misappropriated. Now, misappropriation is not allowed under the law. So in that event, there is one view that no sanction is necessary because it is an offense. But there is another judgment of the Supreme Court. Both judgments are of the Supreme Court. In one case, judgment Supreme Court says no sanction is required because committing of an offense is not a part of the public servant's duty. In another case, Supreme Court says that no, he might have committed an offense, but he has committed it in the color of exercise of his office, and therefore it is in purported exercise of his duty, and therefore his action cannot be proceeded unless the government grants sanction for his prosecution. Now, in a case which came as a complaint case, sanction was necessary. Magistrate sent it to police for investigation. Now, when the magistrate sends it to police for investigation, it is called in exercise of power under section 156, subsection 3. This is very popular exercise of power. A number of complaints are filed every day, and the magistrates need not necessarily deal with every complaint. There is no so much of time. So in that event, he sends it to the police for investigation. Now, in one particular case, a division bench of the Supreme Court about 5-6 years back has laid down that magistrate could not have sent without applying his mind, and therefore the cognizance has not been taken, and the sending to the police is illegal. To my mind, this is a wrong reading of the law, because this is an exercise of power under section 156(3), which is at the pre-cognizance stage. Before the cognizance is taken, there is no bar on my part as a magistrate to send a complaint to the police for investigation. I am given to understand that this judgment of the Supreme Court has been referred to a larger bench, because if the Supreme Court has realized that this judgment is incorrect. So what I wanted to point out is that while dealing with the complaint, I am repeating once more for clarity, when a complaint is made before a magistrate, he has two options. One, he can proceed with the complaint as a complaint. In that event, he records the statement of the complainant and of the witnesses present, and then proceed further as laid down in the CRPC. And after everything is collected, he finds that there is an offense which is disclosed and the accused needs to be summoned or his presence procured by way of warrant. He issues the warrant or the summons as the case may be. The other one is when the complaint is presented before the magistrate may decide that no, this is not a case where I can proceed as a complaint case. It must go to the police for investigation. In that event, cognizance has not yet been taken, and that is why it is permissible to send. Say, for instance, if it is a case of rape, I decide to send it to the police for investigation, because apart from recording of a statement of the complainant and witnesses, there may be further investigations to be done. Forensic examination is required to be done. Medical examination of the girl is required to be done, so on and so forth. So in that event, I have not. And my sending of the complaint to the police for investigation, where the police will be required to register a case, is called exercise of power under section 156(3). So if it is in every case which a magistrate sends to the police, he has not taken cognizance. Cognizance is said to have been taken only when the magistrate decides to proceed with the complaint as a complaint case, and where there is any legal impediment in the taking of the cognizance without another stage, just like sanction I said. So in that event, if the sanction has not been given, the court cannot take cognizance. Let me tell you that in a case where cognizance is barred because of lack of sanction for prosecution by the government, there is no bar for investigation of the offense. So if a complaint is made before a magistrate that somebody has done, say, involved in misappropriation of fund, then in that event, if it is sent to the police for investigation, magistrate has not taken cognizance, and the police will be competent to investigate the case. Investigation is not barred, and cognizance is barred. So Supreme Court, why the Supreme Court was wrong? Because Supreme Court said he could not have sent it without taking cognizance. No, magistrate can send to the police a complaint without taking cognizance. And when he sends it, it's called pre-cognizance stage. Now, he takes cognizance only when there is a police report on completion of investigation. He finds that he discloses an offense, and then he issues the process for obtaining the presence of the accused and proceeding to the trial, if necessary. So basically, this is I've made it very short so that it doesn't become too boring. Dr. Batra, if there is any question you want to get from the audience, you can tell me.
Can you get me back in the screen with Dr. Ansari? It's an honor. With Justice Ansari, it's an honor to be in a screen with him.
I feel very well.
Good looks and is having hair. So I definitely balance that out. वो हिंदी और उर्दू नजर पट्टू कहते हैं, तो मैं वो नजर पट्टू बन जाता हूँ. So on a serious note, I heard your concern. I'm not a legal professional nor a lawyer, but just on a commonsensical basis, it appealed to I want to ask you if the right definition in the spirit in which you said what you said is applied. Do you think that the pendency of cases will come down, or at least the mischief happen between the courts and police? If I am maybe candid about it.
If the court is vigilant and it exercises power properly in the cases where the exercise of power is needed, and refuse to exercise where the power cannot be exercised, then in that event, obviously, it will have in the deduction of the case, and we will have only cases with the not merit, but where we have to proceed. Those cases will be alive.
Thank you so much.
One more thing, Dr. Batra, I want to say, these days, earlier there was no training for judicial officers. These days, trainings are being organized by various judicial academies. As a matter of fact, you may be happy to learn that Assam, that is Northeast, was the first one where the judicial training was organized, because of the reason that in the states like Manipur, Nagaland, Arunachal, Mizoram, there was no separation of power. That an executive magistrate was also a judicial magistrate. A district magistrate was a deputy commissioner. He was also the sessions judge, and he was also the district judge. So if you want a divorce decree, you will have to go to the district magistrate. If you want a 302 trial, that means a murder trial, you will be before the same district magistrate. It was a very peculiar system, and it has not been fully avoided, but then separation has taken place. So in order to enable the executive officer exercise judicial power, it was thought necessary that there has to be training provided. That institution's name, which is no more, is Northeast Judicial Officers Training Institute. I was in charge of it as a judge. And subsequently, now there is an academy made. And of course, the National Law School is also there in Guwahati. So the training of the judicial officers are organized.
Thank you so much. Congratulations on that development, and thank you for bringing it in. My last question to you, because the panel is waiting, is there is these BW Legal World 40 under 40 young legal leaders and legal influencers. What is your word of advice to them so that they can make an impact in this ecosystem?
I am unfortunately a rebel. So those who are hearing me have to take it very seriously, but at the same time very carefully so that they don't put themselves in trouble. So the law is something which cannot be said to be perfect. And that is why a judge of the Supreme Court said of the United States, we are supreme, not because we are infallible. That means we are supreme not because we cannot commit mistake. He says we are supreme because we are final. So had there been another Supreme Court over the Supreme Court, many of the cases of the Supreme Court would have gone to that particular court. And that is what exactly happens when we say that a case has been referred to a larger bench, means that the earlier bench's decision was incorrect. That is why it has gone to a bigger...
Imperfect. I wouldn't call it
is,
incorrect. There were imperfections.
That is why every student of law must, as a student, not read the judgment as law. It should be read as a judgment, which may be full of human follies. He must go through the judgment. The judgment is binding on the legal side. Let us be very clear. Judgment is binding on the legal side, but the God Almighty has given us the wisdom. We cannot surrender a wisdom to a judgment. Otherwise, if a judgment is wrong, we will also commit the same mistake. I will give you a very small example. A statement made by a co-accused cannot be used against the accused unless there is some other substantive evidence showing the involvement of the other accused, if there are two accused. Right? I give a statement against my co-accused. On the basis of that, on my statement, you cannot say, for instance, Ria has given a statement against her co-accused. On the basis of Ria's statement alone, they cannot be convicted. There has to be independent evidence available. If there is evidence available, then Ria's statement can be taken for the purpose of corroboration. This is the law. Unfortunately, the Supreme Court in one particular case said that confession is no evidence, and therefore confession of accused cannot be made basis for conviction. This judgment was wrong. Even when I was a session judge, I could see that this judgment is incorrect. And subsequently, the Supreme Court laid down that yes, this judgment is correct because the court has relied on a judgment which was given on a confession of a co-accused. And the second thing which I would like the students to know very much is that the head note of the cases are not law. They are only editorial comments. So please don't rely on them as the proposition of law. Go through the judgment and understand the judgment yourself. Because if the editor commits a mistake, which was committed in this particular case, then in that event, you will also understand the law incorrectly.
Thank you so much. What Justice Ansari, the former Chief Justice of the Patna High Court, formerly at the Assam, he was in Assam, he was in Guwahati, is saying is two things. I hear him. One, he's saying, do the right thing for the right reason, the right, get into detailing. Yeah, and he rightly said that the Supreme Court is final because it is final, not because it is right always, right? I can't, as I look at. Second, he's talking about get into detailing, read it, but it's a judgment. It's so read it as a judgment. That's what he's saying.
It's a human instrument.
Yeah, it's an human instrument. And so these are technical things. As an attitude, like Justice Geeta Mitchell just said to us, just before you, she was our speaker, and she said, I would say the 3 H's for all the young lawyers: hard work, humility, and honesty. So what are your 3, I don't know, what's your framework? What is your word of advice to these young professionals?
I will add humanity also. Because unless there is compassion, one person cannot be a very good judge. You have to have compassion.
Compassion is the most important quality for a leader or any human being.
However serious the charge against an accused may be, you must take him to be innocent until the time he is proved guilty. This is not only for saying, it is in your behavior, in your conduct, how you behave inside the court with the accused, how you let others behave with the accused inside the court, whether it is police, it is lawyer, anyone, or it is visitor. That is what I am saying.
Thank you so much.
These days we have seen sometimes when an accused is produced in the court, he is beaten, and not beaten only by the visitors coming to the court, by the lawyers, which is absolutely unacceptable as far as the court is concerned. So that humanity is something which the court has to bear in mind. So another H, with Justice Geeta Mittal's 3H.
Thank you so much. I'll add my own. Humility is the most important to me. Humility and compassion, hard work and honesty. But I would say, add, you have to be a PhD. Like I have a PhD, but it's a permanent head damage. I have permanent head damage, but I'm referring to my hair and nothing else. But I would say passion, hunger, desire. You have to have passion for what you can't just be a lawyer because you want to make money, you want to be famous. You have to make an impact. Hunger is when you really strive to do something extra, and desire because you want to. There is a role model like Justice Ansari, somebody you want to be like him or her, or Justice Geeta Mittal. So I think adding to those 3H, Justice Iqbal Ahmed Ansari ji has added humanity, compassion, and he's rightly said that until someone is proven guilty, he's not guilty. I think the media can learn from it, but we have a long way on that. I think we need to get back to the basics. Thank you so much, Justice Ansari, for talking to bwlegalworld.com, and we look forward to another conversation with you soon enough. Thank you so much. Thank you so much. Thank you so much.